Hi, my name is Paul Harding, and I'm the managing partner of the law firm Martin, Harding, and Mazzotti. And we're a law firm throughout New York State, and we do primarily personal injury. And I stumbled on an article recently where Apple was sued in a class action lawsuit for the fact that they were allowing people to operate a motor vehicle and use social media, use apps on their Apple phone. Well, first of all, class action cases are sort of like any other case where you've been injured and you want to go after someone for the damages, you sue them. But then if you have other defendants who are similarly situated, who have similar complaints and kind of sitting in the same place, well, you guys can all combine and then form a class action. And that's what they did here. I don't know if it's the appropriate use of class action, but that is what happened. But here's really what happened. So we've got a driver going down the road, and he is rear-ended by a driver who they find out is using his Apple phone. He's using the app on his phone. And it's pretty clear, and people do know, that Apple does have technology, they do have software they could put on the phones that would shut down when the phone is operating in a motor vehicle based on the motion of the car. And they could do that. Well, they could do that. They haven't done that. If they do that, nobody in a car can use a phone. And so, but the claim is, hey, listen, you could have done it, you didn't do it, other people are getting injured, and we're going to bring a claim against you. I don't think this claim is going to be successful, and we have some precedent to take a look at that. Snapchat, for example, was also sued, and they were sued because someone was using a Snapchat filter, and they were looking at how fast they were going, and then they rear-ended someone. And of course, this always happens when there's not a lot of insurance coverage on the part of the bad guys who are saying, okay, who else can we bring in? Well, in this case, the federal judge found that Snapchat could not be held liable, that there was not a duty owed by Snapchat to the car that was hit by the individual using the Snapchat app. So I think the same thing is going to happen here. I think at some point, maybe there's going to be some legislation that is going to limit the ability to use these phones, to use these chats while this stuff's going on. But right now, I think this case is going to go by the way of the Snapchat case and be dismissed. But it'll be interesting to watch as these cases proceed in the future. We're in a brave new legal world. Thank you. Paul Harding checking in.